his views in that regard. We're neutral on what the sequence should be and on whether it's possible to argue the postponement application first.
Thank you, Mr. Chairperson. A housekeeping matter. We have appearing before us for the first time Mr. Mosigidi, Mr. Tebu Mosigidi. Good morning and welcome to you. Yes. Well, we've seen Ms. Powe countless times, but good morning to you too. Mr. Ngwato, I think the logical thing is for us to invite you to address us on the postponement application. And perhaps let me upfront raise this with you. My understanding, if I did not misread the papers in the postponement application, is that what the evidence leaders suggest is to separate the matters insofar as they relate to the texts, the bulk of which you, admittedly by the evidence leaders, or perhaps not so much you, but your client received fairly recently. So the evidence leaders are suggesting that they must deal with those in respect of which there is no contention or issue around the timing of their delivery, and that the rest will be dealt with in due course. What would you say the problem is with that approach, if I'm capturing what the papers say correctly?
Thanks, Commissioner. I think it is quite clear that the documents have been read, and with that being said, and with that summary, it is in a way towards what the matter is all about. The issue is twofold, Commissioner. Our client received documentation from the Commission as far early as November 2025, and he duly complied with all the requirements in terms of those documentation. And as at December 2025, he received a notification for his appearance on the 20th of January, which at the time there was no problem. However, a day before the 20th, he now receives a notification that he's to appear on the 30th. But he must come back on the 22nd to receive the documentation. Now, on the 22nd, 6 days before the appearance, which is on the Thursday, he now receives a memory stick which contains, according to the evidence leaders, 4,800 pages of documentation that he needs to prepare, and he needs to answer to the Commission in 6 days' time. Given the fact that it was on a Thursday and I was not available, he only managed to consult with me on the 26th, 4 days before the Commission. At that time, we have not even yet opened the documentation, but in meeting with the evidence leader on the 26th on a Monday, it was then clearly indicated to us that more documentation or more files are still forthcoming by end of business. But we still have to be ready by Friday. Now, at that time, we raised the issue to say it's not going to be possible. There's 4,800 pages that we have to go through. We still have to receive some documentation from you. We are ready. The documentation that he received in December and that he has already made statements to the Commission about, that part we are ready to proceed. But the one that we just received now, 4 days before, we can't. We still have to peruse, we still have to consider. We still have to then consult, because it is not true that when a person has to come and appear before the Commission, evidence is only limited to what has been given to him. He may have his own independent evidence that we need to source. He may have to be able to consult and corroborate his versions and narrative. We're not going to have time to be able to do that. We endeavored at all costs to print the 4,800 pages. We only completed printing those documents by 2 o'clock the 27th. That will mean we now fully access the documents at 2 o'clock the 27th, 3 days before. And we had to prepare to appear. Now, my client is prepared to appear at all costs. It doesn't matter it's about who or who. But he wants to, when he does that, he should be able to do that proper without prejudicing his own rights. He should be able to substantiate his narrative and his versions. Now, unfortunately, commissioners, we were since in the last 3 days bogged down by having to make this application. An application for postponement, having to receive the answering, an application to be off camera, having to receive and those type of things. Now, as a result, parallel to all this process, we also had to try to read the 4,800 pages. We are not anywhere near. Now, we also noted the version and the narrative or the kind of compromise that was made by the evidence leader to say, maybe let's focus on this.
May I just ask this, Mr. Ngwato? You say that you are prepared for the commission to proceed today in respect of some of the documents. I just want to get an idea of whether there is convergence between you and the evidence leaders on the documents that you are prepared to proceed with or on.
Okay.
Is there convergence there? If there isn't, where's the divergence?
Commissioner, in our application, the purpose of application, we clearly state for the documentation and representation that we've already made, we are ready to proceed, which is very specific. It refers to the...
Just refer to the convergence and divergence, yes, please, because that still confuses me, because okay, I'm not sure what's what.
So they don't seem to accept it, or they don't accept it. They want the whole full version, the past of last year and the one that was given to us 3 days ago. They want the full-blown aspect. The only compromise they want to make is that on the 3 days, the one that was given to us 3 days ago, can they only now focus on this particular person of interest? And I'm saying that's too dangerous for a client. It is not just about that person. Out of the 4,800 pages, we may have corroborative matters that we need to refer to. And if you are now going to try to now put us only to this 100, as if it's only about this 100, it's also misleading. Because this is a person of interest, and this was not just an independent, isolated, just person. It's a whole concocted group of people that were involved in this. So therefore, it then means that we may have to... Do you
mean concocted, or did you mean some other verb?
Commissioner, what I mean is that it's intertwined and interrelated. It's not just an isolated aspect. It's one person. You don't have just a relationship with just one person that is only concluded there. It's one person that you know through somebody and the other person and the other person. Therefore, it might be that your corroborative information is not only found only in his file, but is found in somebody's file. So we then have to read everything, and not just only that, because the narrative will be very wrong and very misleading and will be very limited. But for our defense, it is important that our client is properly consulted, peruse the documentation, consider the documentation, and more importantly, the context in which whatever comments he made, they were made under.
Yes.
So, unfortunately, the evidence leaders are of the view that we can deal with the first part, and then on the second part, only deal with this one. And this is where we say no. On the second part, on documents we received 3 days ago, we request to be given time to peruse, consider, and consult. We don't want to come before the commission like what we've seen already on TV, on people coming and appearing before you unprepared, and now having to answer to questions that they were never given an opportunity to. We want to be clear and fair and assist the commission in whatever way, and he's willing to do so, but only if he's just been given a fair chance. These documents specifically are said to have been downloaded from his cell phones. His cell phones were taken from him in October last year by SAPS. Now, they had 4 months with his cell phones. to download the documentation, but they give him less than 4 days to prepare what it took them 4 months. But it's not just about the 4 months. The relationship that he had with those people may go 40 years or 4 years down the line. How is he going to be able to deal with that in 4 days?
There were no cell phones, were there? 40 years ago. I'm not sure, maybe there were.
I'm just giving you to say the relationship that he has with these people is a long-term relationship. It goes beyond decades. It's more than 10 years that he probably have known these people. And whatever has been downloaded from his cell phone is not necessarily maybe only from last week. It may go back, and he may have to then give you context on that. Now, they downloaded decades of WhatsApp from his phone. They took 4 months to download it or to deal with it or to consider it or to analyze it, and they want to give him less than 4 days to answer about it. He's not even having these phones. The phones are with them. He does not have any other source to say, how can I refresh my mind? It's not like he's been having his phones all the time and he's been going through these things all the time. He doesn't have these phones anymore. They are with them. And it may be that some of the information we need may be still in those phones. What if we may need to say, no, let's call back the same phones because you have not downloaded all the information. We need to see some of this information. We don't want to even begin to suggest that some of the information that has been printed, we may say, no, this is not how it is, it's been tampered with. It leaves a lot for us to, it then suggests that we need a lot for us to then go through. And to have to be given 3 days to say, this is 3 days, if you can't deal with these 3 days, or consider going through them over the weekend. It can't be. I'm in a private practice. I have other clients. I have commitments already. And it cannot be presumed that I'll automatically be available to assist this client over the weekend without even the decency of asking me my availability. We indicated on Monday, this 4,800 will require time to go through it. Give us the time. They don't even ask us how much time we need. The answer is just no, upfront.
And how much time do you need?
We need 6 days.
Sorry?
6 days.
6 days. Yes, Mr. Ngoto.
So, and that shows an attitude of people who have already concluded, and by any other means, they want to continue with it. And it becomes, Commissioner, a very concerning issue. As in the middle of consultation yesterday, the President made an announcement, media statement, where the same client that has not even testified, his name is there, that there's a prima facie evidence and therefore the SAPS must investigate him. He has not given evidence. The fact that when General Khumalo presented his evidence showed him carrying a bag, that does not mean that he's transporting money. And this now already impacts on him.
I'm not sure what the relevance of that is now, Mr. Ngwato. And effectively, I don't know to what extent you have engaged with the terms of reference of this commission. I will tell you now that the commission actually does have powers to do that. You are not criticizing the president. You are criticizing the commission. Of course, I will be the first to admit and accept that we are not beyond reproach. If we must be criticized, I will welcome that. Freedom of expression, the Constitution itself. I have been a justice of the Constitution, of the Constitutional Court, So I understand you have the right to criticize whoever, but the point of substance is, on my reading of the terms of reference, we are perfectly entitled to do what we did. That referral was made by us, not by the President. So unless you first engage with the terms of reference and tell me why we are not entitled to do what we did in respect of that witness, I think you are going beyond the realms of what you are entitled to traverse.
Thank you, Commissioner. Let me clarify what I mean by that. What I mean by that is that my client has not given any chance, right of response to the people.
That we have heard, and I think please try to wrap up because I think now you are getting to the point where you are repeating yourself.
No.
I'm not gagging you. I'm not gagging you.
Yes, I was just saying. I said, Honorable Commissioner, let me clarify what I meant by that. What I meant by that was, and without sounding, having to repeat myself, is that he has not been given any right of response by anyone under any circumstances, whether in writing or oral. But such a submission has already been made to the public, and it's quite of great importance to this person because it affects his right. And unfortunately, Commissioner, it may be unsettling and uncomfortable, but it's the truth of what actually happened. And now, when the evidence leaders approach us, in light of these circumstances, where narratives and issues has already been said in the public domain, especially from the office of the president, coming from the high reputable commission of this nature, it is of concern that I want to go and present, and I'm not being given a chance to do so.
Oh, just a minute. Please continue and please try to wrap up, Mr. Ngwato.
Thank you,
and
Commissioner.
please try to focus on the application before us, the application for a postponement.
Just in short and in conclusion, Commissioner, says that my client is prepared and ready to testify about the evidence and the request and the documentation he received in 2025, in which he has since made the written representation to the Commission. That part is okay. The second part of what is required of him to testify about, which is documentation that, and the bulk of documentation that he received on 3 days before the Commission, he's not ready to do so because he hasn't had enough time to peruse. That's in a nutshell, that part. We're not rejecting everything in totality. It is only the part on documents that he has received 3 days ago.
Thank you, Mr. Ngwato.
Thank you, Commissioner.
Mr.
Mr. Chaskasi, sorry, let me just clarify. Mr. Ngwato, you, in paragraph 3.1 of the application, you say this is an application wherein I request order, which order directs the hearing scheduled 30 January with regards to 13 files. So it's the 13 files that you are
Indeed.
concerned about, that you are seeking to be heard later.
Yes, indeed. Those are the 13 files that were received 3 days ago.
Okay. All right. Thank you. Thank you.
Can I just clarify something? I'm looking at paragraph 4.4 of the founding affidavit. Especially the first two sentences on page 7. What I understand the affidavit to be saying there is that your client is ready and prepared to testify on his witness statement that he provided on the 16th of December 2025. And he can do that today. But the 4,800 documents that he received a few days ago, he cannot testify on that because you have not had time to consult with him on those documents. So you need a further 6 days to go through those and to deal with those. But today he can give evidence in chief based on his statement of the 16th of December 2025. Am I understanding you correctly?
100% correct.
Mr. Chaskasi.
Chair, there have been a range of factual assertions made here which are just simply wrong. The contention of 3 days, well, let's start at the beginning. It's not 4,800 pages. There's an evidence bundle in front of you which runs to 849 pages, and there is an annexure bundle with 540 pages. That's a total of 1,389 pages. The memory stick containing all of these documents come from the WhatsApps of the witness. The witness's counsel or attorney complains that he doesn't have his phones. But any of us who have a WhatsApp account know that when you get a new phone, you upload your old WhatsApps if you want to. The fact that his phones were taken away sometime in October by the SAPS doesn't prevent him from accessing his historical WhatsApps. He can access them. We always assumed he would have accessed them. The third factual error is that we haven't had these files since October, whenever they were seized. They were seized by the SAPS. We obtained them from the SAPS only this month. So we haven't had much time with them either, but yet we have managed to work out what we want to ask and answer and have answered in relation to them.
Does that mean the SAPS seized the documents for their own purposes? And then you requested the documents from the SAPS?
We got access to them under notice from the SAPS, under compulsion from the SAPS, but only this month. And there was a lengthy period beforehand over whether we could only ask for materials to be provided to us after they had been downloaded, and I don't know what the SAPS were doing between now and October, but we obtained those materials this month. If I understand Mr. Ngwato correctly, he needs another 6 days. But it's important to have regard to the chronology here. Mr. Nkosi, until earlier this month, was due to appear on the 20th of January.
May we take a short adjournment, and
sure.
May the evidence leaders and the legal representative please see us outside. Please continue, Mr. Chaskolson.
Mr. Commissioner, sorry, excuse me.
Sorry. Yes.
Apologize. I was not joined by my colleague earlier on, so I don't want to be surprised that I'm not being joined by my colleague, Mr. Malika from the same Malika.
Good morning, Mr. Malika, and welcome. Thank you.
Chair, Mr. Ngwato appears to have been involved in this matter since December, or since before December. He was aware that his client was due to appear on the 5th of December. He was then aware that his client was due to appear on the 20th of January when we couldn't accommodate the hearing of his client's evidence on the 5th of December. When the Commission's resumption was delayed, his client was contacted because Mr. Ngwata wasn't on record at that stage. The client was contacted and said, we're only starting evidence on the 26th of December. You were due to appear on the 20th. Can we meet with you to discuss the appearance and to make arrangements for documents on which you will be questioned? The client was called to a meeting on 20 January and attended the meeting on 20 January without an attorney. At that meeting, we impressed upon the client the importance of having an attorney present in future meetings. But on the 20th, it was explained to the client what he would be questioned on, that a memory stick containing the chats extracted from his phone and made available to the Commission would be given to him 2 days later on the 22nd, and that on the 22nd he would be given an indication of which particular WhatsApp chats the evidence leaders would be focusing on when they questioned him at the hearing commencing on the 30th today. That duly happened, and if one goes to page 22, one sees that the memory stick was handed over on 22 January. So the client has had all of the documentation that the Commission intends to rely on in today's questioning for 8 days, not for 3 days. Why it's 3 days is that...
And that's the 1,000 and something.
Well, no. He's had the whole memory stick, which contains a whole lot more. But if you look at the letter on pages 22 and 23, it identifies particular chats. The most important chat files on which you will be questioned are the following, and then they are listed. Those are the chat files that broadly are included in the evidence bundle that's before you, and those are the ones that are that run to slightly under 1,300 pages. There's an additional.
So that's is that what's referred to itemized rather? Is that what's itemized at page 23, 3.1 to 3.13?
That's correct, indeed.
Thank you. Yes.
There are possibly an additional 40 pages.
And I'm sorry again. And what's itemized there, 3.1 to 3.13, is that what's itemized there? Is that what you say totals 1,000 and something?
No, it totals slightly less. Because there are approximately 40 pages. If you compare those 13 with the index on the front of the evidence bundle, you will see that there are 2 or 3 additional items, but the total of those additional items won't run to more than 50 pages.
Thank you.
Mr. Ngwata, for his own reasons, decided only to get going on assisting his client in this regard, not on the 22nd of January, or indeed on the 20th of January when the client was called to a meeting, but I think 4 days later. He now says he needs an extra 6 days to get on top of this information. Well, 4 of those 6 he's chosen not to exercise himself. We want to get going on the questioning of this client. We don't want the witness. We don't want the witness to be compromised. We have put forward a proposal, which is that we will question him with regard to his chats with the 3 individuals in respect of whom he in respect of whom he addressed his relationship in his statement that he handed in December. We will want him to answer those questions, but in respect of anything else, we will indicate what we infer from these chats, and if he wants to come back at a later stage to address that or to furnish a statement addressing that, he can. The real evidence is in the chats. The client's insights into the chats would be welcome for this commission, but if the client is not ready to address all of the chats, well then, and he needs more time, we said to him, you can say, I'm not in a position to answer this question now, apart from those 3 individuals' chats. please come back to me. I will consider the issue once I've been thoroughly through all of my WhatsApp chats on the memory stick, and will furnish a supplementary statement later and come back and be questioned on it.
What's your response to Mr. Ngwato's submission that what falls outside of what you referred to in, is it what, 3.1 to 13, whatever the number is, but 1 to 13, the submission is that it may well be that what falls outside of that itemization may have an impact on what's within the itemization, and that they want to go through what falls outside so as to see whether there is indeed such impact, and that's necessary in their process of recognizing the witness.
My immediate response to that is that I know the questions that I intend to ask, and in 90% of the case, that problem will not arise. Well, I would be astonished if that problem genuinely arose. But I am willing to extend our offer to cover it. If there is a bona fide case of the witness needing more time to answer a specific question, from our side, we're quite happy to put the question out there. And if the witness bona fide says, well, this is something that I can't answer because I need to look at other chats, we'll say, well, we'll tell you what inference we want to draw from these chats, and when you have looked at the other chats, you can furnish a statement and you can come back to be questioned on it. But it is an issue that I know the questions I want to ask, I know the chats. It is an issue that is not going to arise in the vast majority of cases.
And I will also say this, and I'll afford Mr. Ngwato an opportunity to respond, but I may also say that to the extent that when Mr. Ngwato and the witness go through the rest of the material and a view is taken that something within or in that information bears relevance to what's in 1 to 13, they may always come back and say, we want to testify and show that.
Of course, there is nothing that they
there's any number of ways to address that. Yeah.
We would welcome a supplementary statement from this witness, but we don't want the process of the Commission to be derailed over the next 3 days. The evidence on the chats is very important for the way in which this Commission proceeds.
Yes, perhaps I should correct myself if the impression I gave is that the only possibility to address it would be for the witness to come back and give oral testimony. It could be by way of a statement, it could be by way of any other means that we as the commissioners may think of. And as I said, Mr. Ngwato, you will respond to what I've just put to Mr. Chaskalson.
Mr. Chaskalson, if the witness is if the witness is entitled or will be allowed to say, I'm not going to answer because I haven't considered all the documents and I will come back, what is the harm in granting the request that you penned any discussion relating to all of these documents? I guess another way of asking my question is, what is the benefit or urgency to put to him your questions about the balance of the documents, to do that today and in the rest of the allocated dates, vis-a-vis leaving out that part completely for when he does return? And I ask the question because it's not obvious to me that because you have identified specific documents that you're going to look at and you have an idea of the questions you're going to ask of him, it's not obvious to me that it is fair to proceed on the basis that, well, all we will be doing is putting to him what we are making of these documents and the inferences that we will draw, and then he can say, I'll come back another time. I'm not sure, it's not so obvious to me, and I'm not saying it's unfair yet. I'm just saying it's not clear to me that it's not, that it's fair to proceed that way, but also the agency of let's do it that way today. There's a need to do it today and put all of these questions that are going to be, put to him, and they will be out there playing out, and he will get a chance another day to answer. I know I've spoken long. I don't know if you've captured the essence of what I'm asking of you.
Well, there are several points in response, Commissioner Baloy. First, I expect the witness to approach this process in good faith. And most of the questions that I want to ask are questions which, as I see it, will not give rise to a problem of a need for more time. So there will be a great deal that can be achieved if the witness does answer in good faith. And I have no reason to believe that the witness won't. Second, a lot of the chats that I want to put to this witness are chats that in due course we will want to put to other witnesses as well, witnesses on the other side of the conversation. And it makes sense for this witness to be questioned on these chats before the other witnesses, because in many cases he is the fulcrum for a series of chats, and you don't understand the chat with witness B with witness B unless you've also seen the chat with witness C. Putting that evidence out at this stage makes a lot more sense than delaying the process of this witness and the process of witness B and the process of witness C to a later stage, always assuming that this witness will approach the process in good faith. And then finally, in relation to fairness, we're being, in my submission, excessively fair to this witness. What we are saying is we will tell you all of our concerns. We will put out there everything that worries us. You will have time to reflect on that with your attorney. This is not the ordinary process of questioning where you are, as it were, taken by surprise by a question. You will see the questions all in front, and if you want to answer them, you can decide to do that at a later stage. I don't think there's a fairness concern. The witness will be treated with a great deal more fairness than any other witness. He will know, he will see our entire hand, not just the documents, but also how we put the documents together, the questions that we want to ask on the documents. And then he will decide, does he want to try to address them in response or not? If he does, he will have the opportunity of doing that. And he will have a much better opportunity of doing that than most other witnesses.
The second of the three that you've listed, it seems to me, though, that the second concern, that your discussion of these WhatsApps is matter that you will need to cover, or that you're going to cover with other witnesses that are still that, to me, is more a scheduling issue, at least on the face of it. It's a scheduling issue. If you don't cover those WhatsApps now with a witness, then you have to change your schedule. But if they're as central as that, then you would have to reschedule your other witnesses so that this witness comes back before those other witnesses.
That is correct. It is essentially a scheduling issue, but it would mean disrupting the entire schedule as it's currently being planned. But there is finally a much more fundamental objection that I have to this postponement application, which is that the witness has had enough time to prepare for the hearing on all of our questions. The witness, the position of the witness has chopped and changed. The witness seems to be conflating the request under a Regulation 10.6 notice to furnish a statement on certain issues, which will serve as the statement in chief of the witness, with our right to question the witness on his relationship with certain parties. The summonses that have been served on the witness since December have made clear which relationships we are interested in. None of that has changed. That's what my questioning is going to go to today. And the witness has had ample time to identify what he wants to say in relation to that. His complaint is that in December, when we asked that question, he didn't know that we had or we were going to get his WhatsApps. That's his complaint. That, with respect, is not an issue of fairness. He has had potential access to all of those WhatsApps at every single stage. If he wanted, in discussing his relationships with the 4 people identified in the summonses he's had for 2 months, to do that thoroughly and exhaustively, he was always in a position to do that. And even after we told him what WhatsApps we had obtained and we made them available to him, he's had 8 days. These were not sprung on him yesterday. They were sprung. The full set of WhatsApps was given to him 8 days with a list saying we're going to focus on these ones.
Please give me the total of what you refer to as these ones. You gave it when you started. You said it's now 1,000 and what?
The total pages in the evidence bundle that we've prepared and the annexure bundle is 1,389 pages.
1,389. Please continue.
Sorry, that also, and I think I can that includes, I'm not sure how many pages, but it includes some correspondence as well, which is independent of the WhatsApps and has been correspondence exchange between the Commission and the attorneys and the witness.
Sorry, Mr. Chairperson, when you say it's 1,389 pages, are you saying in your questioning you're going to focus on all 1,389, or are you saying you gave him 1,389, but in those 1,389 you have identified the ones that you're going to be focusing on?
Well, the bundle, which I'm going to be focusing on and I'm going to be addressing questions to him on, runs to 1,389 as I see it at the moment. The memory stick that we gave him on the 20th of January runs to more. I haven't ever looked at the total number there, but we then identified 13 chat streams. That is slightly less than 1,389.
What was the purpose of giving him the 4,000 plus if the focus is only going to be on 1,389?
We were giving him everything that we had so that he knew everything that we had. If he wanted to use something that we had, or if he wanted to see what we had, we don't fully appreciate the relevance of all of what we see on the memory stick. And we had called him to testify in relation to 4 discrete, a series of topics, including his relationship with 4 people. We could see that some of these WhatsApps were clearly relevant to that. We gave him everything so that he knew what we had.
If we were to postpone, but because now we are no longer talking 4,000 and something, but substantially less. If we were to postpone, but instead of the 6 days, postpone for a shorter period, would that work? If not, why not?
It would probably mean that the Commission would have no one to testify on Monday and Tuesday. It certainly mean that there'd be no one to testify today. It would create very serious scheduling problems for the Commission in this respect, in that I don't know what a shorter postponement would look like, but we wouldn't be able to run this evidence the following week. There is an entirely different my own sense is that if this evidence were to be postponed, looking at a schedule, it could probably only be accommodated from the week of, I think it's the 16th of February again. Which would then knock on, which would mean that other witnesses would then have to be pushed further. At the moment, this commission wraps up on the 26th of March. It may be given, the 16th of March, not the 26th of March. It would create very serious scheduling problems. Certainly without an extension beyond the 16th of March, it would be impossible to accommodate.
Just throwing ideas around at this stage, and by no means indicating an inclination. We'll probably, after all the submissions, have to adjourn and discuss our minds, but I just want to throw in all the ideas at this stage so that when we adjourn, we have everything before us. If, for example, we were not to sit today, give Mr. Ngwato and the witness, I know he complained that suggestions are made on matters that impact on his time without us knowing how he stands with regard to his time or timing. But we do not sit today, and we give him and his client today and the weekend, and then we start on Monday. I know the scheduling is only, that is next week, will only be, or is only for Monday and Tuesday. How would that be for you? I know you wanted 3 days, so you will be having 2 days, but...
We won't finish, but we will certainly make some progress.
And Wednesday's witness is totally out of the question to do something there.
It may be possible to. I have an availability problem for 1 day next week, and I don't yet know which day it is because it's an urgent application. I will find out when it is. It may be possible to switch a witness around and to try to finish this witness in the course of next week.
As I said, none of this is indicating any inclinations. It's just testing everything. Yes, Mr. Shaskal. Any further submissions?
None from me, thank you.
Thank you very much. Any reply, Mr. Ngwato? And You may also reply to the issue on which I said you would have to, or you may, if so minded, also reply to. And then also bear in mind that Mr. Shaskalson says that it's only 1,389 pages that the evidence leaders want to deal with, and not 4,000. And that I think as a matter of professional courtesy, they gave you everything, which is the 4,000 plus.
Thank you, Commissioner. Maybe let me start at the low-hanging fruit, the last aspect as to 4,800 pages as opposed to 1,300 pages. If you get given 4,800 pages and you don't know which one is 1,389 out of the 4,800, it's a difficult process. You are given 4,800 pages.
But from 8 days back, according to Mr. Shaskalson, you have now since known that it's the 1,389 that's going to be focused on.
Very much incorrect, Commissioner, and I'm going to come and address the aspect that he mentioned that our client had access to this documentation more than eight days back and those type of things, because it's very wrong. Even the suggestion that the client has had this thing since more than 8 weeks is also very wrong, and I did not address this issue at the beginning because I felt that we have surpassed things.
Days, not weeks.
Weeks.
8 days. I thought Mr. Shaskalson
No,
said
Commissioner, in their replying...
Days, not weeks. 8 days, not 8 weeks.
Correct, Commissioner. Now he says 8 days. In their replying, they're saying 8 weeks. And I was going to be able to clarify these two aspects as to 8 days versus the 8 weeks that they also suggest in their answering affidavit. But what I was simply saying to you, Commissioner, is go through them and understand what all of them are. Because if you don't, and you appear and they say, no, but this was part of the documents we gave you to you, you can't say, but I never looked at it, because it was given to you. You are duty-bound to still go through the 4,800, even if they're going to focus on the 1,003. They did not just take the 4,800 for nothing. It simply means there is of some relevance. Hence, they put, out of the memory stick, they put all those 4,800. And Commissioner, the 4,800 pages was not my counting. It was his counting. He's the one that told us when we met with him on the 26th that it's actually 4,800 pages. I endeavored, when we printed this documentation, to verify his 4,800. Now he says, no, it was not the 4,800. Actually, far much lesser because of the documentation. We received the bundle of documentation, the bundle of documents, which is the index that is now before you, or the index and the paginated bundle that is before you, a night before, a day before. And then when we looked at that, now it now comes to 1,800. The rest of the other things have been excluded. But as from Monday to up until yesterday, we're still under the impression, based on what he informed us, that we're going to receive...
Please repeat, when do you say you became aware that the relevant pages were 1,389?
Not the relevant pages, Commissioner, for correction. When we looked at the index and paginated documents that we sent a link to yesterday, we then realized that from the link, the documents that they've included on the index and paginated documents amounts to 1,300, plus an additional bundle of about 400-something documents, right? But as from Monday, when we printed, when we dealt and interacted with the Commission, we interacted on the base of 4,800 pages. And in the letter that, and maybe I should refer you to the same document that you had referred to the Commission to, where they say these are the bundles or files that the Commission will focus on. They even state further that they will, on the next date, they will then indicate which one to focus on. So at no stage before did they say to us, we've given you the 4,800, the rest of the matters are irrelevant, just focus on the 1,003. The 1,003 became quite very clear to us when we received the paginated documents. But even if that been the case, Commissioner, as an attorney, when you receive the 4,800, you are in no way in a position to upfront to say, ignore the rest and only focus on the, unless you've been told upfront which one are those. You are duty bound to then go through the 4,800 and then from there make an informed decision which one are relevant and which one are not relevant and which one you need to focus on. But preparation cannot be piecemeal. You have to prepare in full. And that is the challenge that we had on our side, because we have a duty
Please continue, General.
Thank you, Commissioner. We had a duty to advise our client properly. And our advice will be based on having had access or having analyzed the matters fully, not piecemeal. Now, if the documents now that he's going to focus on, we should ignore the 4,800 and now focus on the 1,300, is something that we could look into going forward, to say all other materials will now be irrelevant, and now the now relevant material will be as stated in the bundle of document that has been before the Commission. That is something else we could look into. But with that being said, Commissioner, understanding the importance of this Commission, we started looking at that 1,300 last night already, plus the additional 500. And we are nowhere close to finish to say he can start testifying on that, because we just received the link yesterday or last night. So we already started.
Would Monday be in order? Would starting on Monday be in order then? You say you started going through those. So assuming that we postpone until Monday, so you would have today at the weekend, and then we start on Monday. Would that be in order? But as I said with Mr. Shaskalsin, that's not necessarily an inclination. I'm just raising that to you or with you to hear your submissions.
That suggestion was ventilated already when we met on Monday with the evidence leaders, that I'm unfortunately not available on weekend. So they knew already, as from Monday, that I will not be available on this weekend to be able to then see.
Mr. Ngwato, you are a practitioner. I'm sitting with practitioners. I was a practitioner for many, many years. We always try, if something comes up and something that's quite urgent, we always try to make time. Are you telling me, as you are sitting there, that you simply cannot make time to attend to this very important national matter, or rather matter of national importance?
Commissioner, I fully understand what you're saying. In agency, there is no convenience. I'm 100% with you there. But I had to pre-warn them. And had it been that we had...
That was a discussion with the evidence leaders. You are discussing with me now, and I'm raising a matter of national importance, and I'm asking you whether you are telling me that you simply cannot make time.
Commissioner, yes, I understand that is the issue that we...
If, for example, you will tell me that you are attending a wedding, it's not your daughter's, it's not your son's, I doubt that I would necessarily be satisfied with that. Or if you are attending a funeral and it's not a funeral of a close relative, I'm not sure that I would understand that. I'm just giving two examples. There's any number of examples.
Commissioner, it's a medical issue. And that is why I clearly indicated to them my non-availability, because it's a medical issue and I cannot postpone it.
Is that a matter, I was about to say, is that a matter in respect of which you have an appointment? I'm not getting into the content of the medical, which is something personal. I'm not getting into that. I'm just asking, is this a matter in respect of which you had to make an appointment?
Without divulging the medical issues, Commissioner, is a matter that unfortunately I could not postpone, and is medical issues relate to me in person. If it is something that I could easily move away, and hence I brought it to their attention and discussed it with them in time, whether to find an alternative means, I would have done so. But because of we could not find each other, and today is the 11th hour, it's going to be even much more costly and impractical for me to then try to postpone and make myself available for this weekend.
Just repeat that, I'm not sure I follow. So are you saying it's something that you could have postponed, but it's just that you and the evidence leaders could not find each other? Is that the point you are making?
I'm saying if at the time on Monday there wasn't such an arrangement, then I should be given an opportunity to try to postpone that or deal with that matter,
So the sense I get from what you are saying then is that a postponement is a possibility. Am I correct?
No.
Aren't you saying that had you and the evidence leaders found each other much, much earlier, you could have attended to a possible postponement? Did you not say that?
No, Commissioner. And
Please make me understand then.
We might be given an opportunity to then clarify that.
Not giving you an opportunity is the last thing I would ever want to do, Mr. Ngwato. Please, you have the time.
What I'm saying to you, Honourable Commissioner, is that one, it is the reason of my non-availability as the attorney of record is a medical issue, and unfortunately I cannot move it. Because I've been aware of the impending medical issue for this weekend or appointment, I've brought it to their attention as early as Monday. And unfortunately, no, we could not reach an agreement on that particular aspect or on the postponement. Again, at the time when we...
So when is your appointment for? Is it for tomorrow?
I'm leaving tonight.
Sorry?
I'm leaving tonight.
Or it involves traveling? Oh, okay, all right. Coming back when?
Sunday.
Or what time on Sunday?
Midday, Sunday. It will not be
all
night.
Right, okay.
Ms. Ngwato, Annexure E to the application, page 22.
Annexure E?
Yes.
Yes, Commissioner.
And we must try to work together here because the Commission does not have a lot of time. It's a letter dated 22 January, so that's 8 days ago. And in manuscript it says there that the witness collected the USB on the 22nd of January, so that's 8 days ago. But paragraph 3 makes it clear that the chats that will be the focus of the questioning are the chats between him and the 13 people identified on page 23. So why can't we use the rest of the day for you and your client to go through the chats that relate to him and the 13 people so that today is not wasted, it is used productively? And because we were going to sit on Monday and Tuesday anyway, we continue with the evidence on Monday and Tuesday, accepting for a moment that you have a difficulty on Saturday. If the chats are identified, you don't have to go through 4,800 pages. You go through the chats that are identified, and your client was told 8 days ago already that he's going to be asked questions on the chats with this. It's not even 8 people. Because some of the people there, it's not 13. Some of them are duplicated. Sandile Kumalo could be using 3 numbers, for example, as you can see from items 3.1 to 3.13. So because today was a sitting day for the Commission, and you said your client is available to give his evidence in chief today for the rest of the day, why can't this day be used to go through the chats with those 13 people so that come Monday we are ready to continue with the work of the Commission?
Okay.
So, Mr. Ngwato, maybe before you answer, also deal with this. And I'm just trying to see if we are not speaking at cross purposes. I have understood you to say you are ready to, or the witness is ready to testify on certain topics, and these are the topics about which he was informed last year, and that exclude these chats. Am I correct in that?
That includes these chats?
No, that exclude these chats. Okay. So if these chats are excluded from discussion between Mr. Chaskalson and the witness, if the final position today were to be that these chats may not be raised, the witness is available and ready to testify today. So we won't have a wasted day. Am I correct in
You're correct, Commissioner.
I have understood. Is that
Yeah.
the position?
You're correct. And maybe let me just clarify to Honorable Commissioner. The first documentation that our client received in last year refers to a different set of chairs outside this 13, which has since submitted a written statements towards that. That we've always been ready since last year and is ready to proceed with that today. With regards to the 13 files, these files that you referred me to, page 22, which is Annexure E, which was received on the 22nd. Here he received the USB, right? It's not the documentation. He received the USB. From the USB, he still has to go and print. The 22nd was Thursday last week, right? From once he has received this on Thursday last week, he then contacted my office to make an appointment. And unfortunately, again, due to my non-availability, I can only meet with him Monday morning before we meet with the evidence leader, so which is the 26th. Now, we met with the evidence leader on the 26th. And again on the 26th, we said, yes, we have received the memory stick. And as yet at that time, the client has not been able to print because he does not have a facility at his house to print a voluminous 4,800 pages at that time. And like in this letter, as it is clearly crafted, it says, and it reads, the Commission will be referring only to these chart files when you appear to testify on Friday the 30th. By close of business tomorrow, which is now the 23rd, we will provide you with a full list, which is to date still not been given. We'll provide you with a full list of the relevant chat files to which you may be referred when you come to give evidence. Now you refer to me to paragraph 3. That part is still outstanding. They haven't still been provided that. We can inform you now that the most important chat files are the 13. Now, on this 13, I see, and it's quite becoming clear to me that Mr. Chakalson says, no, it's no longer 4,800. It is actually 1,300. And on the 1,300, we'll only focus on this particular part, right? The request is the 1,300, whether it's the 4,800, the request time to then peruse them so that we understand the full context, we understand the full narrative of the 4,800 pages so that we can now testify. But however, the one that we've already submitted written response on, we're ready to proceed on this one. This 1,800, we don't even know what the questions are going to be about them. And without even being given the questions, we just need to then be ready that at any given point we might be referred to page 920, may be referred to page 20. This is not a person who's as legally trained like me who can be easily juggle around the document. This is a layman who for the first time might be testifying in his life. He needs to be properly guided in terms of how to respond to those issues.
You're not entitled to questions in advance. As long as you have the documents and you understand what the document is, you can be asked a question about it. And my point was that because the files are ready, you don't even have to go and print 4,000 pages because they have been printed. I've got a bundle that's going to be used in relation to this witness. My simple question is, I don't want a situation where we say, today we are ready to proceed on the evidence in chief, but we're going to waste Monday and Tuesday, and he will come back in February. I was hoping that if you use today, because the bundles are ready, and you go through the chats with him so that he knows which chats they are, and he's ready to answer questions when he's asked questions, then we use Monday and Tuesday productively. Because I don't think it helps to say, let's start his statement today, but let's not sit on Monday and Tuesday. Because then we're wasting time and we may never recover it. That's really my issue.
Commissioner, I don't want to sound being difficult or not appreciative of the agency and the importance of the matter at hand. But the reality of the matter is, Commissioner, even if there may be 1,300, as I indicated earlier on, we are not bound to only rely on that in our responses. We have to also be able to find any other information that may help us in responding to any other questions or that assist us in responding to the matters at hand.
Any further submissions, Mr. Ngwata?
Yes, Commissioner. In fact, I was to respond to the submissions made by Mr. Chakalson, but it's immediately thereafter questions start coming in, and we have not yet responded to that aspect. But I don't want to then deal with matters that will no longer be of importance. But there's some specific issues that are of importance, Commissioner.
Yes.
And I'll summarize them maybe into 3 or 4 aspects. One, the evidence leaders are indicating that our client needs to approach the commission with good faith and answer questions in good faith. That being said, is that good faith is also required from the evidence leaders in giving him the proper time to be able to analyze and respond adequately to the questions. And what we're saying that simply because of the bulk of documents that were now submitted to him in less than 3 days ago. And I was trying to explain to the Honorable Commissioner that even though he collected on the 22nd, then counting from the 22nd will make 8 days. He never had access to them for 8 days. He only had access to them only as from the 27th. And the evidence leaders were fully aware of that particular scenario. That's point number one. And therefore, good faith will dictate. If a person only receives a document 4 days before the commission, voluminous as they are for more than 1,000 pages, he needs to be given a chance to be able to peruse them. That's number one. Number two, he then referred to the emails. Commissioner, there's an issue here and we need to accept this thing. Maybe the evidence leaders need to approach the commission with honesty and integrity. The first correspondence that were sent to the client were sent to a wrong person. He never knew of the number of people that were involved in the first bunch of documents. This number of people that were referred to in the first correspondence to him were sent to an incorrect person. He only first time received the correct names of people that he needed to answer to on the 2nd of December, and he responded to that. This person that they are now focusing on is the same person that they included, excluded in their own previous correspondence, which they were sending to a wrong person. And now they want to say for 8 weeks, which is what they stated in their answering affidavit, for 8 weeks you've been aware of these documents. But they did not want to accept the fact that the email they used in that 8 weeks they're referring to was an incorrect email, which is what we stated in our replying affidavit, and he never had access to that. So it's only now this witness received the documents on the 2nd and duly complied with all the requirements that were of him and submitted. And now on the 19th of January, when he's supposed to come, they say come back on the 22nd, there's a memory stick you are to receive. So they now want to try to portray our client as an uncooperative person. This is and without admitting on their side that there was an error on their side. They have been sending correspondence to a wrong person. He never been receiving this information. He only received the information. And now because of a scheduling issue, which has nothing to do with him, now he needs to compromise his rights and to accommodate scheduling. Scheduling cannot be as important as the constitutional rights of a person, the right to prepare and the right to a fair trial. Scheduling can never be of such importance. If there's an issue on scheduling, they must find a way how they rearrange things on his side, but not to his prejudice because of scheduling aspect. And that's another comment that I wanted to be able to make there. With regards to the charts, Commissioner, like I said, I've already had access to the charts and I've already started studying the charts. It's not just the charts. It is the charts, it is the videos, it is the outgoing calls, it is the incoming calls, it is the documentation. It's not as simple as it's been portrayed to be that now it's just mere charts and it's the charts that he made. But these charts or this documentation involves other people, like he said. He says it could be coming from this person and going to this particular person. Our client cannot come here and just give blanket statements without corroboration, because it would just be hearsay. He needs to then say, I'm saying the following issues, and this is my bundle of evidence that I want to submit to the commission so that I can clear my name. Otherwise, the narrative will be, this is what it is. And it cannot be that our response or defense solely relies on the bundle given by the evidence leaders. So we have a duty, if we have any other counter evidence, that we have to produce that. And for us to then produce that documentation or evidence over the weekend, we may not be able to have access to those documentation because that's state information or the information that has been held through his employer we may not be able to do that. Hence, again, the aspect of a weekend is not attractive to me, over and above the challenge that I personally have. So the request, therefore, is, and I was looking with my colleague here in terms of how quick we can accommodate the commission, given the fact that I may not be available. I initially said 6 days, but if we were to start on Wednesday, so that I can have the 2 days, Monday and Tuesday, to thoroughly go through the documentation with this client to then finalize. Because you don't just read it once and then you're okay. You read it once and at the end you realize, but I read something on this file that's important to this particular file. Let's go. You have to clearly bring him to understand the implications of what he says. And I humbly request, this is not a process you can push over. This is not a process that you can rush over, because you're speaking about somebody's life. You're speaking about somebody's dignity. This matters for generations to come. We will be referred to his dignity. And it cannot just be rushed because of the scheduling aspect. That's my submissions, Commissioner.
Thank you, Mr. Ngwato. Oh, I see your microphone is on, Mr.
Chair,
Mr.
I just wanted to correct another factual inaccuracy in one of Mr. Ngwato's submissions. If you go to the replying affidavit, I mean, Mr. Ngwato seemed to suggest the client first knew what he would be questioned on sometime in late January. If you go to page 66 of the reply, he admits, as he has to, 816, on the same day, 2 December 2025, I received the summons in terms of section 3.2, which confirmed that my appearance date is 20 January 26, which included the name of Mr. Motsumi. This was sent to the correct email address, Detective F.E. There it is. If one goes to page 49, one sees that summons, delivery by hand and email, and that sets out the relationships and the topics that I want to question him on today. He's known these topics for almost 2 full months.
Thank you, Mr. Chairperson. We will adjourn, but we ask the evidence leaders and the witnesses' legal representatives to see us outside just now. Thank you. Let's adjourn. careful consideration, we have taken a decision, and the decision is to postpone, but it will not be for as long as Mr. Mkhwanazi asked for. The matter is postponed to Tuesday next week. The main reason for that is that we, to an extent, do understand the plea that time is required to go through the documentation, and we feel that in fairness we should not be too nitpicking about when exactly the documents were received or when they were not. We just decide that in the circumstances of it all, fairness dictates that we grant the postponement, and that will be to Tuesday, 3 February 2026. We make the order.
Thank you, Chair.
As to what happens from Tuesday, we will see from there. Thank you. Thank you, Mr. Chaskalson.
Chair, can I make one submission? In order to save further time, can we address the issue of the remote hearing application today?
Yes. That was our idea. That was our idea. Mr. Mkhwanazi, do you want to address us on that? And
Chair, can I ask that this hearing is addressed in private and possibly not in this auditorium but somewhere else, because I think both parties might want to refer to matters or facts that would defeat the purpose of a closed application or a remote hearing application if they were ventilated publicly.
Even the very reason that's been given by the applicant, which in the main focuses just on one aspect really. So not even that in open session.
I certainly, I mean, the evidence leaders certainly have their own concerns, but maybe we can proceed as...
We've seen that the evidence leaders go beyond just what's been stated in the application itself. The evidence leaders they are quote unquote at this stage informal support for the application. Formally, we are yet to be addressed. So my issue was simply whether even the main reason that's been stated, whether that cannot be stated in open session.
I don't see a problem with investigating that in open session. I'm not sure what Mr. Mkhwanazi's attitude is. Certainly our responses and may need to be ventilated privately.
Yes, yeah.
What I do want to say, and just to put this clearly on the record publicly, because I don't want to give the wrong impression and expose the witness to harm that way, is that as of this stage, the witness has implicated no people in his communications to us, Yes, and I don't want it to be thought that why I want this to be held in private is anything along those lines. The witness absolutely has not implicated a single person. Part of my complaints about the witness's statement and issues I want to take up with him questioning with him is that he has implicated nobody.
Nobody. Indeed, the statement that we have been furnished with goes to quite some length, not implicating any people, and any of the people mentioned, there are explanations by the witness, all of which do not implicate the people concerned. Mr. Mkhwanazi, would you have any problems if at least the main reason. I do not know whether your idea of the main reason and my idea of the main reason are the same, but would you have any problem with at least the main reason for the application were to be stated in open session?
Yeah, thanks, Commissioner. Indeed, yes, we will have a problem with the main reason being done on an open session. We share the sentiments with Council, the evidence leader. We have attended and addressed this particular aspect, and we definitely know the type of evidence that is going to be required. Yes, he has not implicated anyone, but whatever evidence he is going to lead or may lead, potentially may end up bringing some people to light, and that's goes towards the main reason. And for that, we'd like to maybe approach.
But perhaps what I should place on record, and you'll correct me, my understanding is that the application is not for the evidence not to be heard publicly. Or is it? I thought it's more off camera, but not that it should not be heard.
That was certainly my understanding of it too, that it will be broadcast, but that the witnesses' face will not...
face and name.
Face and name will not be disclosed.
Correct, yes.
Yes. Let us adjourn then to hear the application in camera. Let's adjourn. The witness subpoenaed to appear on 30 January 2026 has applied for his testimony to be presented partially in camera. That is, his image and name not appear publicly. The application is supported by the evidence leaders. Having heard the nature of the evidence involved and the persons to whom this evidence relates, the Commission is satisfied that the physical safety of the witness may be put at risk if his image and name are placed in the public domain during his testimony. The Commission accordingly orders that the testimony of the witness will be presented without mention of his name and publication of his image. We so order. Let's adjourn until 9:30 on Monday. Let's adjourn. Thank you.